Hi everyone, Keith Carlson here again for Carlson and Jayakumar, looking at some of the cases that we've been reviewing in the first part of October, both healthcare and employment related cases. First, a healthcare case called U.S. versus Stem Cell Treatment Center, Inc., a Ninth Circuit decision reversing the district court. The district court had ruled that a concoction of a patient's own stem cells, other cells, and cell parts, a mixture known as SVF, had actually not been a drug administered and thus not subject to FDA regulation. As the defendants had argued, the practice said this was actually a surgical procedure using the defendant's own cell parts, and that it was not FDA medication that would need regulation. The Ninth Circuit has reversed that ruling and said that it is not a surgical procedure and thus must be regulated by the FDA. Also in the healthcare realm and involving the Ninth Circuit was U.S. v. Solakyan, upholding a conviction of Sam Solakyan, who apparently had bribed or offered kickbacks to various medical doctors and chiropractors to send patients to an imaging center he had an interest in. This kickback scheme was to defraud the California workers' compensation system. He was charged on honest services and healthcare fraud. His defense on appeal was that the doctor-patient relationship did not extend into these fraud protections, and thus he should not be convicted. The Ninth Circuit rejected that argument, upholding his prior convictions. One that touches on healthcare and employment is Mooney v. Fife. Mooney, the plaintiff, sued his former boss, dermatologist Dr. Fife, and the related practice under the False Claims Act, the FCA, under a retaliation theory because he had, as the former COO, reported what he believed to be fraudulent or illegal billing practices and was subsequently terminated. The district court granted a motion for summary judgment on the practice's behalf, but the Ninth Circuit said there was enough evidence shown that the firing may have been pretext and that it was a violation of the anti-retaliation protections of the FCA. So that is going to head back down to the district court to look at the issues involving retaliation in FCA claims in this area. Also on the employment front was Wentworth v. Regents of the University of California. Professor Wentworth brought a appeal to the California Court of Appeal because the trial court had granted a dispositive motion that had thrown out a number of his claims on FEHA failure to accommodate grounds, as well as privacy violation claims. The Court of Appeal upheld the FEHA failure to accommodate claims on summary adjudication, but turned the questions of privacy back to the trial court for adjudication. The issue being the professor alleges that both student complaints as well as requests for a disability accommodation were disclosed by the university to the media and other faculty in a faculty meeting, and the Court of Appeal believes that employee privacy claims had enough teeth in this one that it was going to need to go forward. And then last up for the beginning of the month was Doe v. 2nd Street Corp. This is another arbitration provision which we've been seeing a lot of, in particular under the Ending Forced Arbitration in Sexual Assault and Sexual Harassment Act, a federal act. In that act, it says that it is going to be applicable to any acts that occur after passage of the act, and this case of Doe versus 2nd Street had acts of sexual assault or sexual harassment occurring both before and after passage of the statute. The Court of Appeal determined that arbitration cannot be compelled when there are both acts before and after. It is going to be litigated in Superior Court rather than arbitration because some of the alleged acts occurred after passage of the arbitration prohibition or protection for those signing arbitration provisions involving cases of sexual assault and sexual harassment. So thank you for looking in, and those are a few of the cases we've been looking at here in the first part of October. Hope to see you soon. Thank you.